No disrespect to Mr.
Well, you're about to then. Go ahead. Did you have cocaine in your possession?
Yes, sir.
All right. Had you used it?
Yes, sir.
Did you know what you were using was cocaine?
Yes, sir.
All right.
Can I address the court, Your Honor? Can I address the court, Your Honor?
I'd advise against it. I've advised him to speak to me first.
Sir, you want to address the court? Your counsel has advised you that it may not go for you to do so. So
I and my attorney don't see things the same way. So I would, right now, like opportunity to get another attorney.
okay. And how do you intend upon doing that?
I beg your pardon? I'm hard of hearing.
Work. Can you hear me now?
Yes, sir.
So with reference to an attorney, how are you intending upon doing that?
I'm going to ask to have another one appointed to me.
Well, it doesn't quite work that way.
Okay.
Your Honor, this is news to me. I did see Mr. Edwards yesterday, and there seemed to be no issue.
So you've actually talked to Mr. Brown?
In this whole procedure, I may have talked to Mr. Brown, maybe about an hour, 15 minutes here, 15 minutes there, 5 minutes here and 5 minutes there.
Okay.
This is my first time ever being in court in any type of way.
Okay. So what am I supposed to take from you?
That I'm not satisfied with my attorney. And I think I should have.
So what are you not satisfied with?
Our communication, my understanding of anything.
Have you been listening to him?
Yes, I have.
You have?
I've been listening to him.
And you're telling me Mr. Brown hasn't properly communicated to you or with you? Because if you're going to say that, I don't believe it for a minute. He's one of the finest attorneys Washtenaw County has. So you can go ahead and say what you want, but I'm letting you know the perspective I'm coming from.
No disrespect to Mr.
Well, you're about to then. Go ahead.
Yeah, that's exactly what I'm saying.
Really?
That I don't understand.
Okay, you not understanding doesn't mean that the attorney isn't doing their job. I don't see a basis upon which to take Mr. Brown off this case. Now, if you want to hire your own attorney, you can go ahead and hire your own attorney.
Okay, that'll be the next procedure that I'll try to do then.
So you're going to try to hire your attorney. How much time you need to do that?
I'm not sure, sir. I don't know.
Well, I got to set a date. How much time do you need? You don't like the best that Washtenaw County may have to offer, and now you want to hire somebody else. How much time do you need?
Well, first of all, I got to try to come up with some money.
Oh,
okay. Then second of all, I have to have someone to help me find an attorney.
Mm-hmm.
How long do you do that?
Is it a such thing as a pro bono attorney?
A what?
I may not be pronouncing that correctly, but I'm a lot of dental work.
This is where the defendant makes a critical mistake. In American courts, you don't get a new court-appointed lawyer just because you're unhappy. The judge needs evidence of a serious breakdown in communication, not simply frustration. Watch closely. The courtroom is about to deliver a reality check.
Pro bono attorney, yes.
A pro bono attorney.
Yeah.
Meaning one that is a good attorney that you're not paying for?
Yeah.
That's what you want?
Basically, that's what I'm saying. Yeah.
Okay, so you realize standing next to you is one of the best that you're not paying for right now. Yeah, I know. I'm shocked.
I wouldn't challenge that.
You would?
I wouldn't challenge. I said, I'm not saying he's not. I'm just saying.
Oh, so now you're not saying he's not.
I've said what I've said.
Mm-hmm.
And
So to the extent that is even a proper motion to permit withdrawal of the public defender's office and Mr. Brown, that motion's denied. I don't see a basis upon which to do it.
So, Your Honor, what I'm going to ask to do is to adjourn this for 1 week. So that,
1 week?
yeah, so that my client and I can have a chance to talk and find out the nature of his discontent.
Probable cause conference will be adjourned. 1 week has what, the 6th? June 6th, 2024. 9 a.m. as your invite indicates, bond will continue. All right, Mr. Edwards, I'm going to make a suggestion to you before you take those off.
Beg your pardon?
I'm going to make a suggestion to you.
Yes, sir.
Rather than doing a whole lot of thinking yourself, when Mr. Brown comes and talks to you, maybe you ought to listen to him. And then if you have questions and you may not understand something he's saying, you should probably just ask it. And then you'd have probably a better understanding of what's going on, and we don't have to go through this again. Thank you. Have a great day.
Your Honor, this is day and time set for PCC. We respectfully request that to set this for exam.
I have a community corrections bond violation.
Yes, Your Honor, I have discussed that matter with my client, and we are also ready to address that as well with the court.
Why don't you address that before I set it for anything?
Pardon me, Your Honor?
Why don't you address that before I set it for anything?
Absolutely, Your Honor. So I did speak about this with Mr. Obich. He represented to me that he did not report to community corrections since his release from the jail. Upon his release from the jail, he did not receive any bond violation or bond paperwork or anything like that, and was not aware that he had to report. Upon finding out that he did have to report last Thursday, May 23rd, he states that he called community corrections and spoke to someone.
From what date is he saying he didn't know he had to report?
When he was released from the jail, I believe on the 11th, Your Honor, is that correct?
I believe it was a Saturday. No. On the 11th of May?
I believe so, Your Honor. And he said he did, upon his release, didn't receive paperwork and then had not reported at all until May 23rd. He states that he did call and speak to someone. He does not recall the name. And they told him to just keep calling his number every day, which his number is 5. And since last Thursday.
So why did he start calling on the 23rd?
Because I called him and told him that a warrant may be on its way and to get in contact with community corrections immediately, which he did. He represented to me that he did call community corrections. They advised him to continue calling every day with his number. He represents to me that he has been doing so every day that they have been open since last Thursday. He states to me that his number is 5.
Notice how the judge keeps asking the same question in different ways. That's a courtroom strategy to test credibility. If the explanation keeps changing, it weakens the defense and makes it much harder for the judge to believe the defendant's version of events.
That number 5 has not been called since last Thursday. He did also state that he is 1,000% ready, willing, and able to test. He is willing to do so right now. He just did not realize that upon his release from the jail that he had to go do so. So he actually is.
So he was testing before.
Yes. And then
put in jail.
Yes, Your Honor.
Comes out of jail. So explain to me the rationale why testing wouldn't have continued.
Because he has another pending case, Your Honor, in circuit court with other counsel. And to my understanding, bond conditions have changed in that case.
Had what?
Had changed in that case. And Mr. Obich represents to me that he thought they had changed in this case as well, and that he was no longer required to test, but he is ready to test today.
So in a circuit court case, he's not required to test anymore?
That's what he states to me. Is that
can I speak? So I'm confused because I have these different court dates, but they're trying to put it under a global resolution. So I don't understand where and when or what I'm supposed to follow on, because sometimes I go to this court and it's like everything's under a global resolution. So I'm really confused on where I even begin to what I'm supposed to do.
Why was he remanded on the circuit court case?
I don't know, Your Honor. He has private counsel.
It's a positive cocaine test.
Yeah.
And he is required to test in a circuit court case. Those conditions have not changed. He has the exact same bond violation. Bond violation report in that file that he has in this case.
I was unaware that, Your Honor. He does have private counsel in that matter. I was just told that his bond conditions had been changed by Judge Slay at some time. Mr. Obich states to me that when he was incarcerated after his remand, he had another court date. And when he was released on that case, he did not understand that he was supposed to report to community corrections from his release from the jail.
When was that?
His release from the jail, Your Honor?
Yeah.
I believe May 11th. Mr. Obich does not remember when his last court date was in circuit court, so I can't speak to that. Our request at this time, if Your Honor would allow, is to allow him to go test right now. He represents to me that he would test clean, and we would ask the court to re-refer him to community corrections. And frankly, Mr. Obich did say he would be willing to go there every day to test if need be. He's been appearing for court regularly, he hasn't missed a court date, and he just asked that the court allow him to go test.
When is he supposed to next appear in front of Judge Slag?
28th.
June 28th.
28th? We're not setting this for anything. He's going to have to try to figure out a way. If he's got private counsel, you're going to have to contact them to try to do that. Did you have cocaine in your possession?
Yes, sir.
All right. Had you used it?
Yes, sir.
Did you know what you were using was cocaine?
Yes, sir.
All right. And what happened that makes you think that you were disorderly on that date and at that location?
I was leaving in my vehicle.
You were weaving in your vehicle?
I mean, I knew I was under the influence of cocaine. Yes, sir. I mean, I don't understand what you're saying.
No, I hear you, but how does that?
If I can.
Yes, go ahead.
Mr. King, you also were in possession of a double-edged, non-folding knife at the time of this offense.
Yes, I was.
And it was carried in your vehicle at that time.
Yes, it was.
All right, you want the higher charge too.
The court will accept that.
All right. Do you have any objection to me doing that? I would accept his plea to the higher charge for the lower charge of disorderly. Given that, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B. Probation sentencing in this matter will be
June 27th at 10 a.m. before Judge Washington.
June 27, 2024. What time?
10 a.m.
10 a.m. before Judge Washington.
Thanks, Your Honor. And if I can get a brief moment to address bond for Mr. Cain-Cross, he'd like me to address bond.
Briefly.
Yes, Your Honor. I represented Mr. Cain-Cross at the PCC back a few weeks ago, and he was sitting next to me in the courtroom. He got severe anxiety. He pretty much had a panic attack, and he left the courtroom and regrets the decision he made. So he wants the court to know that he started thinking about his father, who's 90 years old, who requires full-time attention. So Mr. Cain-Cross made a split-second decision that he obviously regrets.
How did he come back into custody?
Your Honor, it was, I believe, a routine traffic stop. He was.
So he didn't turn himself in. He got picked up after leaving the courthouse?
Yes, sir.
Correct.
Okay, yeah, go ahead with your bond argument.
Thank you, Your Honor. So he's been in custody for 2 weeks now. I visited him this week. He understands now what the consequences to his actions were or are. So the nightmare that he was dreading in the first place, he inevitably brought upon himself by leaving this courtroom instead of if he would have just faced the music. So I looked at his convictions. I looked at his iChat. I don't see any other open cases. To my knowledge, he's not on probation, not on parole. I believe this is the only thing that's holding him. So he apologizes to you in this court. He promises this won't happen again, and just hoping for a chance to be out of custody.
I don't need a response. Motion for bond reduction is denied. Bond will continue.
Thanks.
Thank you.